Yesterday, we did the Thomas Rule, which I think could also be called the Miller Rule or the Miller Test. I like to call it the Thomas Rule, which is the right to keep and bear arms is not a second class right that should be treated differently from any of the other Bill of Rights enumerated. So that's important for us in New Jersey because if you take that a step further, the right to bear arms should not be treated as a second class right, treated differently than the right to keep arms, right? So, and I think that one, the Thomas Rule, is going to be important. I think this is my reading of Bruen, with the exception of taking justifiable need out of New Jersey. In Bruen, the next most important thing for us in New Jersey, and for all the people that are having trouble getting carry permits. Okay, so we've got two groups of people, three groups of people. Let me put it into three groups. There's the people who applied in the very beginning, so let's say very, very late July, August of 2022. They had a lot of trouble getting their permits out of the police chief. There was a lot of delays. I think there was some kind of internal policy or plan among some police chiefs to hold these permits for the full 60 days, which kind of stretched out into a 75 to 90 day range. They eventually worked themselves to the court in a bizarre manner of almost like the Pony Express, delivering them to the court. They're delayed for an extended period of time, and then they show up at the court, and then the court's not holding hearings, the court's not issuing permits. There was a blast of permits in the very beginning, maybe 30 to 60 permits were issued in some counties, and then nothing. Then there are another group of people that applied early, never made it out of the police department. December 22nd rolls in and their permits are still at the police station and haven't been issued yet. So that's an issue, a most bizarre issue. And there's three police departments that I know of that are absolutely brutal for this. And let's throw in there the state police, because some of these barracks in South Jersey, this is just a melee trying to get a permit out. There's guys at 163, 187 days. And then there's the new people who are trying to turn in their permits post December 22nd, where the chief has to issue it, and we're starting to hear a lot of we're not accepting them because we're waiting on guidelines. We don't have the paper for the printer. We don't know how to get the we weren't issued any permits. There's just one excuse after another. So what came out of Bruen, which I think for New Jersey is probably the second most important part of Bruen, which the first part obviously gets rid of New York's proper cause, which simultaneously takes down New Jersey's justifiable need, which we know in New Jersey came from an illegal internal policy of assignment judges from December 1968, written by Edward B. McConnell, and it was a no exceptions policy. And when I say a no exceptions policy, it was no one other than law enforcement or security guards were to receive carry permits. And so there were some rules that came along later in the Sicardi case in 71, and then again in Priest in 1990. And Priest would say under the Sicardi rule, you must have specific threats, previous attacks, both of those are plural, and a special need for self-protection. All three of those came out of Franklin Zimring's National Commission for the Causes and Prevention of Violence, which was published in 1968. But that's where the assignment judges got it from, and that's where the Sicardi rule came from. Remember, that thing doesn't enter the New Jersey Register or the New Jersey Code in 1968 or 1969. We know it's not in there in 1 NJR 30 in 1969. And so it doesn't show up in the code until 1991, and it doesn't show up as an administrative rule coming from the superintendent. It came in as Supreme Court precedent from Priest, which is really Supreme Court precedent from Sicardi. So really for 20, 24 years, that thing kind of sat in limbo as an illegal policy. It's not written in the New Jersey court rules, and it wasn't written in the New Jersey Register. It was never filed with the Secretary of State, and it never made it into the administrative code. And when it did, it didn't make it into the administrative code as a rule by the superintendent. It came in as an internal policy from assignment judges, which was put into Sicardi court case in 71, then sat around for 20 years, and then Priest kind of doctored it up a little bit, and then the code absorbed it as precedent. Okay, so that's where all this stuff stems from. Now, it's a little bit interesting that it looks like a couple days after Bruen, the Attorney General puts out a directive that all of 2C58-4's application procedures are going to be followed. The only thing for the police chiefs in the court is that there will be no more justifiable need. That's not what happened. There was a whole new Sicardi-ish set of obstacles that applicants had to go through. And that's why I think that the Bruen Shuttlesworth citation in note number 9 is so important. So let's get to that. Now, I'm going to read the whole note number 9. I'm going to read it to you because I think it's important, instead of my synopsis of it, to read it so you understand what it says. Because we went over some of it yesterday with the Thomas rule, and we'll have to dabble with that a little bit today because it's important. So let me just read that to you. Note 9. To be clear, nothing in our analysis should be interpreted to suggest the unconstitutionality of the 43 states shall issue licensing regimes under which a general desire for self-defense is sufficient to obtain a permit. Because these licensing regimes do not require applicants to show an atypical need for armed self-defense, they do not necessarily prevent law-abiding responsible citizens from exercising their Second Amendment right to public carry. Rather, it appears that these shall issue regimes, which often require applicants to undergo a background check or pass a firearm safety course, are designed to ensure only that those bearing arms in the jurisdiction are, in fact, law-abiding responsible citizens. Now, here's where it gets super exciting. And they likewise appear to contain only narrow, objective, and definite standards. Now, and that narrow, objective, and definite standards is in quotes. And they likewise appear to contain, quote, only, quote, narrow, objective, and definite standards, end quote, guiding licensing officials, citing Shuttlesworth v. Birmingham, 1969, rather than requiring the appraisal of facts, the exercise of judgment, and the formation of an opinion, citing Cantwell v. Connecticut, features that typify proper cause standards like New York's. Now, this is important because it affects us in New Jersey, and I don't think this is part of the Shuttlesworth rule, but this is going to be part of the Note 9 rule. That said, because any permitting scheme can be put toward abusive ends, we do not rule out constitutional challenges to shall issue regimes where, for example, lengthy wait times in processing license application or exorbitant fees deny ordinary citizens their right to public carry. That one's really important because what we're dealing with here are lengthy wait times, okay? And so we're gonna deal with that one, but we're not gonna deal with it as a lengthy wait time. What we're gonna talk about is the Shuttlesworth citation in note number 9. So they likewise appear to contain only narrow, objective, and definite standards guiding licensing officials. Now, why is that important? Well, in the older version of 2C58-4, the police chief had 60 days to approve or deny the permit. And there was a clause in there that said if the police chief needs more time than 60 days, the police chief was required to send the applicant a letter requesting more time and notifying the applicant of the problem that they were having with the investigation. And no one got that letter. Not one person at the 60-day mark or 50-day mark got that letter. They just went over. And then, as a result of the Karlstrom case in 2019, there was a directive that was issued by the Administrative Office of the Courts by Glenn A. Grant. It was called Directive 0619, which means the sixth directive issued in 2019. And that directive gave the courts 30 days to grant or deny and issue the permit, okay? And so that's part of the definite standard from the Shuttlesworth Rule. So you got 60 days on the police chief and you got 30 days on the court. Now, that 2C58-4 has changed to 90 days in the new law when they took out the judge. I think that's a joke. I don't think there's any reason to have a 90-day investigation on a 2C58-4 permit application, and there's a couple reasons why. A, as we went over previously, we already have the 2C58-3B firearms identification card, which means all the applicants for a carry permit in New Jersey residents have already been vetted. And then B, you got to remember that the law, the original 60 days is from a 1924 law. And there was no other way to do it in 1924 than get references, and then the detective had to flat-foot it from door to door and get your reference checks that way, right? And so that's kind of what took the 60 days. And so I don't even think that references are legal anymore. I think that they are determined on a case-by-case basis, and we'll see that they're thrown out. And there's going to be more to it than that. But remember, and I've said this 1,000 times, there were no fingerprints in 24, and there was no SBI in 24. So what happens, and you guys have heard this from me before, if you haven't, you're going to have to listen to the 575 Gun for Hire with the Waxy Gordon story. But because the Monmouth County prosecutor, Jonas Tooman, was giving bootleggers and racketeers permits in the 30s, and then they found some dead bootleggers in a hotel in Elizabeth, the Berkeley Carteret Hotel, and they ran an investigation and found Waxy Gordon from the FBI's most wanted list had a permit, that there was a big uproar about who was getting permits. And so there's a Fred Fort bill that comes out in 1933, and the Fred Fort bill put fingerprints and an SBI check in there. So this is like right at the beginning of the FBI, right at the beginning of the SBI. And there's no database like we know it today, right? And so as they start to log this database, you got to assume that everything is on an index card, kind of like the Dewey Decimal System when we were kids and had to go to the library. And so now that's not the way the database works, right? Now your fingerprints are electronic. They're in the database. If you commit a crime, they know it, and then it's attached to your SBI number. And so once they run that SBI number, they know if you're a criminal. So there's really, after 1933, and clearly after the state makes us get our prints on Identigo, there's no reason for us to have reference checks anymore. That's just an idiom of bygone era, okay? So we don't need those, all right? But let's not even worry about the change from 60 to 90 at this point. Let's just say they have 90 days. So whether you're operating under the old law, whether you turned it into your chief and your chief sent it to the court, the chief had 60, government had 90. And let me just add a little stipulation there as we're talking about the definite standards, because this is going to play when we start talking about Shuttlesworth. In those definite standards, I think the government kind of thinks that they can use from the police chief to the court, and then from the court back to the police chief as another 30-day delay on the front and the back end. And that is absolute bullshit. It's not written in a law. If you were to read the old law, the police chief didn't send your application to the court after he approved or denied it. If the police chief approved your application, he was to give it back to you, the applicant, and you would submit it to the court. And that's the way that the law was written, was that the court, and the code too, the court shall issue the permit. It wasn't the court shall issue the permit and then send it back to the chief on a Pony Express rider's horse, and then the chief had another 7 or 8 days to delay it because he didn't have a laminator or a card stock or whatever these ridiculous excuses are, okay? So let's talk about definite standards. A definite standard was 60 and 30, 90 days, okay? So when you're talking about note number 9, okay, it's important that you look at the citation, because when they cite Shuttlesworth, when Thomas cites Shuttlesworth, he cites page 151, all right? And so we have to then jump over to Shuttlesworth, okay? And just so if you guys don't understand who Fred Shuttlesworth is, Fred Shuttlesworth was Martin Luther King Jr.'s buddy, and Martin Luther King said Fred Shuttlesworth was the most dynamic force in civil rights in the South, something to that effect. I don't think he used dynamic, but was the most important influence in civil rights in the South, which, you know, if Martin Luther King Jr. is saying that about Fred Shuttlesworth is something. Fred Shuttlesworth wants to have a civil rights march. He applies for a permit in Birmingham, and of course, Birmingham, Alabama in 1968 is not going to give a black man a permit to hold a civil rights march. They delay. He holds his march anyway. They arrest him. They beat the crap out of him. It goes to court. He loses. It goes to Alabama Supreme Court. He loses. It goes to the United States Supreme Court, and they overturn it. And so this case, Shuttlesworth, is about Fred Shuttlesworth and his application for a permit to march, to have a civil rights protest, First Amendment, okay? But now Thomas has taken that and put it in a Second Amendment context in Bruen, all right? And so I'm going to read it 151 to you because I think it's important, instead of me, you know, giving you the cliff notes for you to hear it. So when I put my glasses on, I'm reading notes. I don't ordinarily use notes, but I think it's important that we get this right. There could be no doubt that the Birmingham Ordinance, as it was written, conferred upon the City Commission virtually unbridled and absolute power to prohibit any parade, procession, or demonstration on the city streets or public ways. For in deciding whether or not to withhold a permit, the members of the commission were to be guided only by their own ideas of public welfare, peace, safety, health, decency, good order, morals, or convenience. This ordinance, as it was written, therefore fell squarely within the ambient of the many decisions of this court over the last 30 years, holding that a law subjecting the exercise of First Amendment freedoms to the prior restraint of a license without narrow, objective, and definite standards to guide the licensing authority is unconstitutional. I'm going to stop right there. There's more to it, and I'm going to keep reading it, but I just want to go over that last piece. Many decisions of the court over the last 30 years holding that a law subjecting the exercise of amendment freedom. Let's change first to second now, because that's what Thomas did for us in the footnote. To prior restraint of a license without narrow, objective, and definite standards. And what's the definite standards? 60 days and 30 days. To guide the licensing authority is unconstitutional. What does that mean? That means if your police chief can't get these things out in 60 days, it's unconstitutional. That means if your judge couldn't get this thing out in 30 days, it's unconstitutional. So we don't need any excuses about it's between the court and the police chief, or the police chief in the court, or it's at the prosecutor's office. Prosecutor's office, not even in the statute. They shouldn't even be in there. If you understand the Waxy Gordon story, the prosecutor shouldn't even be involved at all. It's a completely separate show, so let's just stay here. So I'm gonna throw my glasses back on and continue reading Shuttlesworth at 151. It is settled by a long line of recent decisions of this court that an ordinance which, like this one, makes the peaceful enjoyment of freedoms which the Constitution guarantees contingent upon the uncontrolled will of an official, as by requiring a permit or license which may be granted or withheld in the discretion of such official, is an unconstitutional censorship or prior restraint upon the enjoyment of those freedoms. Stop there. They cite Stahl v. Boxley there, which is another case. All right, but again, if your police chief has decided that he's not going to issue your permit for whatever his reasons are, right? Oh, I'm waiting on guidance. That's the one we hear all the time. I'm waiting on guidance. The other one we hear, which we know is bullshit, is we're waiting for your references to come back. Absolute crap. Okay, and then the third one we hear is your SP 66 mental health consent form hasn't come back yet. Well, the reason that mental health consent form hasn't come back yet is because these guys had 60 days and they didn't send it out until day 59. I know that for a fact. Okay, so it's not like they sent it out on day 1 or 5 and they still don't have it at 60. That's a load of crap. It might take 2 weeks, but they had 60 days. And then what's the other one? Oh, the references. Well, your references didn't come back. Well, the references didn't come back because you either didn't mail anything, you didn't call them, or you didn't check yet. And we all know that, right? We know it. And so they don't have the ability to make these excuses anymore. Why? Because now, because of the Note 9 citation of Shuttlesworth, they have definite standards, and the definite standards are 60 and 30 days, or in the new law, 90 days. Which I think we're going to knock that new law down eventually. It should really, if you already have the FID card, be inside of 30 days, but at the very longest, 60 days. Okay, let me go back to Shuttlesworth 151. And our decisions have made clear that a person faced with such an unconstitutional licensing law may ignore it and engage with impunity in the exercise of the right of free expression for which the law purports to require a license. The Constitution can hardly be thought to deny to one subject to the restraints of such an ordinance the right to attack its constitutionality because he has not yet yielded to its demands. Okay, understand, this is not legal advice, but it's important that the government knows that we know this, okay? And so what that means is, if they don't issue your license, if you turn in your application, and then 90 days, and like really, we're not even talking about 90 with some of these people. I did one the other day at 187 days. It means that if they don't issue your permit in 170 days, you could just start carrying your handgun. A, you've already passed the background check because you have the FID card. B, they had 90 days. Those were the definite standards in Note number 9, and they have to adhere to them. So if they didn't, you could carry legally. Now, I don't want to be that guy that gets arrested for that, and neither do you, but that doesn't mean that we can't say to them, hey, what kind of anarchy would result if we all just started carrying at 91 days because you guys aren't doing your job. And that's the pressure we need to put on them. That's what the circular letters do. Okay, so let's move on a little bit from 151, because normally a concurring opinion doesn't hold water. However, Justice Harlan issues a concurring opinion in Shuttlesworth, and his concurring opinion is not a different opinion. It just explains 151, and then therefore I think Harlan's concurrence at 163, this is after the decision, so it'll be like post at 163, is important because we have to start to absorb some of his terminology because it explains the 151 terminology really well. And so here's what Harlan said, and I'm going to quote him again. All right, so I do not mean to suggest that a state may not reasonably require that a parade permit application be submitted early enough to allow authorities to determine whether it is consistent with the important interests which local authority may legitimately protect. But such applications must be handled on an expedited basis so that rights of political expression will not be lost in a maze of cumbersome and slow-moving procedures. I mean, that one's really important, right? Because the whole reason that New Jersey's gun control law was held constitutional in Burton v. Sills in 1968. And this is at page 105. This is what Burton said. New Jersey's gun control law is highly purposed and conscientiously designed toward preventing criminal and other unfit elements from acquiring firearms while enabling the fit elements of society to obtain them with minimal burdens and inconveniences. Well, if that's what we're going by, right? If that's why our gun control law is constitutional, you're already a fit element of society because you already have the 2C58-3B firearms identification card. You already did your fingerprints. You already have the SBI number, right? And so, hold on, that's Cheeseman calling. I'm going to hang up on him and then I'll call him back later. So let me go back to Harlan's concurrence. So there's another paragraph here. Neither the city of Birmingham nor the state of Alabama has established such expedited procedures. The city's ordinance does not establish any procedure at all to govern the consideration of applications. The ordinance does not state how an application is to be submitted to the city commission, nor have regulations been published which would answer these questions. In the absence of any guidelines, the most that can be fairly asked a petitioner is that he make a good faith effort to obtain a permit from city authorities. See how that explains 151? How many people listening to this right now have had a police department, a police chief, a firearms processor, the clerk at the front desk, the lady who handles permits, a court clerk at their court, or a judge say they're waiting on guidelines? We've all heard it 50 times, right? Especially if you're on a firearms syndicate. We all know the stories that we're not issuing permits because we're waiting on guidelines. We're not accepting applications because we're waiting on guidelines. We can't accept your qualifications because we're waiting on guidelines. Ridiculous, right? But what does Harlan do for us in his concurrence? The government didn't print the guidelines. That's not our fault. I think they did. I think the guidelines are actually in the administrative code. They're pretty simple. And all you have to do in the code is take out justifiable need and urgent necessity and go about the way we did it for the last 50 years, and they're there. But these guys are saying, well, we need new guidelines. The new guideline is no more justifiable need. Get the permit, investigate the application, issue the permit. Those are the guidelines. They're saying this because there's a couple things. You're either running into a police chief, a sergeant, a lieutenant, a police department that's anti-Second Amendment, or you're running into a judge that's anti-Second Amendment. And so that's why they say there's no guidelines. Or the only other alternative is your guy is a super lazy guy and doesn't want to do any work. And so they don't want to actually do the work to approve or deny your application. If you've got the FID card, your application is already approved, right? Because we discussed yesterday in the Thomas rule that you've already met the criteria of the 43 other states. You've already done the fingerprints, you've already passed the background check, and you've done the mental health consent form. So you're done. Really, all they got to do is rubber stamp your application at that point. Now, the law and the code and all of the chefs in the stew over the last 50 years have made it so difficult to get a carry permit that these guys still think they're operating in 1969, 1971, and that it needs to be more difficult than it is. It doesn't. Once 1978 happened, you had to have the FID card to get the carry permit anyway. It wasn't in 66 you could get a carry permit without an FID card. You actually had to get fingerprinted if you didn't have the FID card, but not if you did. And so once 78 rolls along, you have to have both now. So once the state does that, you've already been vetted the first time around. They should just issue the second time around. Aside from the fact that your 2C58-3A permit to purchase a handgun is the evidence that you're using, that you own the weapon that you qualified with, right? So once the state police made that regulation, which by the way is not in the code, that's in the state police instructions from their website. Those things hold no water as far as weight, as far as a rule. That's just something someone printed out and put online, and these police departments are going with this as if this is the second coming of the United States Constitution. Those instructions are crap, by the way. That $50 for the permit fee back in the day was crap. That's not written anywhere. That was never written in the statute or the code. The statute or the code were both $20. let's go back to Shuttlesworth. Okay, so the Shuttlesworth Rule. The state has to have definite standards, and if they don't have definite standards, you can start carrying because they don't have them. Okay, and again, not legal advice. That's pressure we need to put on the government. But what is the definite standard? 60 days at the police chief, 30 days to court. What's the new definite standard of this law until this is overturned? 90 days at the police chief. That's the standard. So they have to issue this thing in 90 days. There's no issuing and then we're waiting on laminator. There's no issuing and we're waiting on card stock. There's no waiting on guidelines. It's definite standards. What are the standards? You apply, you knock out all these boxes, right? As soon as you knock out the boxes, your fingerprints are done, your SP66 is done. You know, I don't want to re-argue the references, but your references are done, and then you're qualified. And the qualifications are pretty simple. It's written in the code. You either have to pass a course substantially identical to that of the Police Training Commission, or you have to pass a similar course issued by a certified instructor of the NRA or another certified firearms instructor. Those are the rules. There is no specific course, actual course that you have to take. It has to be close. It doesn't have to be the exact case or course, excuse me. And then the way the code is written, or the use of force test was or. So it was the Police Training Commission test, or the NRA test, or the use of force. So you actually didn't even need to qualify with a weapon the way the code was written. You could just take the use of force test. Now, the state police instructions screwed that all up, and they were requiring the qualification with the handgun. So we don't need to spend any time on that right now, okay? The Shuttlesworth Rule. The state has to have definite standards. The definite standards are written in the code and come out of the statute. Those definite standards are 60 days, 30 days at the court, old law, if it's still at the court, or new law, 90 days at the police chief, okay? And that is important to understand, that we now, as a group, at 187 days, I have mine, but I'm helping people that don't have theirs, as a group, can prove in federal court that the law is unconstitutional because the state of New Jersey is not issuing permits inside of 90 days. I don't think there's one guy who got his permit in 90 days, not one, okay? So the Shuttlesworth Rule, definite standards, 90 days. I'm Jay Factor, New Jersey Firearms Owner Syndicate on Facebook. Remember, you have to join CNJFO. CNJFO is funding these cases right now. They're funding the Coons case, David Jensen down in Camden, looking to get rid of portions of this unconstitutional law. I think the most important one is bars and restaurants and carrying in your car, right? Those were ridiculous. But again, I hope this one helped. If you are confused by it, go back and watch the Miller test, go back and watch the Heller test, go back and watch the Catano